what this means. I'm now joined by constitutional law expert Professor Shadrack Gutto, who's on the line. Thank you very much for joining us, sir. Perhaps you can put some clarity on this for us. The Public Protector has now said she's no longer going to oppose the Reserve Bank's application to review her findings. What does that mean?
Well, what it means is that she has now realized she's going to lose the case in a court of law because the Public Protector's mandate does not include really questions about the value of the currency in the country. That is something which is done by the governor of the Reserve Bank and the committees that work with the governor. But also it is a terrain which belongs to the Minister for Finance. So I think the Public Protector was really in a hurry for whatever reason, but she has now realized that it was a futile exercise on the part of the Public Protector's office. It was not going to get any pleasure at all in a court of law. So I think from a constitutional point of view, it is good that the Public Protector has at least come to understand that there are limits to the powers of that office. It is not open for everything. There are things which it ought to do, whether there is abuse of power, where there's corruption, and so on. And I think that that is where she got it wrong, but it is better sooner than later that she has done it to protect the image of that very important office among Chapter 9 institutions.
Professor, the Public Protector's spokesperson earlier told us that perhaps it's an issue of interpretation and that she had got legal advice earlier and that she's now reviewed that advice. Was there such grey areas that it could have been misinterpreted, or should she have known better?
No, I think whatever advice she had in terms of legal opinion was really neither here or there. And I think upon reflection, it is wise for her not to drag the office in a court. And it's going to be very expensive for that office, which needs more resources to do its real mandate. So I think that it is a wise thing for her to withdraw opposing the case, and we leave it at that, because I think that wisdom has prevailed rather than just emotions and trying to profile that office, which is already has a high profile. She should concentrate on winnable cases.
All right. So what happens now is that the court case continues, the review will happen, and the judges will only hear one side of the story, and her side will be contained in her report. Is that what's going to happen?
Precisely. What it means is that the courts will go ahead to hear the matter. It is unopposed by her office, and that is what we are looking forward to. The court can review. The court doesn't need an answering affidavit and so on, yeah.
All right, so I think to be fair, we must also be clear with our viewers that her withdrawing her opposition doesn't necessarily mean that she thinks she got it wrong, and that often people go to court and you might be so confident about your findings that you don't even need to oppose because you know that the courts will find in your favor anyway. So it doesn't necessarily mean that she's acknowledged that she was wrong.
Well, I think what it means is that it is a case which is unwinnable, on her part.
But does it mean that? It doesn't always mean that, though. You don't have to oppose something. So if she knew that 100% that she's going to win the case, she doesn't necessarily need to oppose it, right?
She doesn't need to oppose it, but I think the powers of that office is not to regulate the value of the currency. And I think that what she could have focused on was the case of the banks, which were found to have done something wrong. If she was able to do that and limit it to that. But I think she opened the door wide open, and it is wise for that office of the public protector really not to oppose the case, to let the court do the review. And after that, she may, if there is any ground, she may then say the review was wrongly done and proceed. But at this stage, I think it is the role of the courts to review. I think there have been judgments where it is said the remedial action really, which is recommended by the public protector's office, can go on review.
Okay. Professor, perhaps just to get a little bit more clarity, is it possible for her to be subpoenaed to appear before this court to explain how she arrived at her decision in the first place? Because as it stands, she doesn't need to explain, and maybe those are difficult questions that she wouldn't want to face.
Yes, she could be asked to go and explain why she really wasted time of the court. There's nothing wrong with doing that, because the courts may want clarity on what was the intention before, so that the court can do a thorough review. So there's nothing wrong about that, but she is not definitely opposing that.
All right. Professor Shadrack Gutto, constitutional law expert, thank you very much indeed for joining us on the line to give us a bit more clarity about what happens going forward.